All right, so we left off at capacity to contract, legality of purpose, remembering again that seller that if you're selling to a minor, that minor has the right to repudiate the contract and can do it all the way up to the day of majority, and all they have to do is return the property or whatever to you. It doesn't even matter if they ruined it. You owe them the money back because it was legal and enforceable. Now, one of the first things we talked about was whether contracts need to be in writing. Well, it turns out the general answer is no, but we will find that there are some contracts that are so important that the law deems it necessary that they be in writing or that there be a proof of them. And they call this the statute of frauds. And I think it's because otherwise we would have people deciding, no, I've got a verbal contract to buy that home. They were down on their luck. I paid X amount of money, or I just bought this. It's really mine. We don't want the courts to have to sit here and try to decide on somebody's word or not. So the legislatures have all gone in and passed statutes of frauds. And generally, this is a matter of state law. I'm unaware of it in the federal system, so I may be wrong. But, here's your list on this slide: transfers of ownership or tenancy in real property. So that even if we've got a 6-month lease, we might have to go ahead and sign a document to show, no, this has changed. But definitely transfers of ownership in real property need to be in writing to be enforceable. And it's just I think that makes relatively good sense. I'm not going to spend more time on that. Any contract which would take longer than a year. Again, if you think about this, we're thinking about what's important enough that you would put it in writing. This is important enough, you would put it in writing. It's going to take us more than a year to get it. I think I gave the Pennzoil Texaco example earlier. Ordinarily those mergers take longer than a year to actually get done, but not always. So, they may have raised this as a defense because this statute of frauds is usually raised as what's called an affirmative defense. Let's say somebody wants to claim that I sold them my home. They're ready and willing and able to pay full value for it. But I want to walk in and go, no, I didn't sell to this person. I may not really be ready to exit my home yet. So what I would raise if they sue me to enforce the contract is I would raise as an affirmative defense, that is a defense that affirmatively denies their proposition or their allegation and says, no, give me judgment right now that what they brought was improper. If I don't raise that as an affirmative defense, I may have waived it. It's something usually in the course of pleading you have to do right off the bat. Otherwise, you've harmed the other party. It's something that should be raised immediately. And then the last one is contracts which exceed a certain value. I think pretty much you can go to the Secretary of State or any other, it varies from state to state who is the keeper of the statutes. In Missouri, I believe it's Secretary of State. You can always go to the clerk of the legislature, has at least the pending statutes, and that would link you to who has the real statutes, whatever. But you can usually search these online real easily and just put in Statute of Frauds, Missouri, and it should lead you directly to that. Oftentimes there are others, but those are the ones that come up the most frequently. The next item is something called the parole evidence rule. And this kind of plays off the statute of frauds. If we have a writing and a provision is missing from it, well, there's something called the parole evidence rule that prohibits the use of oral testimony when there is a writing. Okay, if there is a writing, its language controls. All right, and so I've put in here that it's similar to statutes, inclusio unius, exclusio alterius. Since we have provisions in the contract, it's absurd that we wouldn't have written this claimed provision into the contract. So that if they're claiming that we were to give all of our appliances in a sale of our home, which, you may or may not know this, but ordinarily the appliances don't go with the home unless they're actually listed. I have the right to take my refrigerator with me, to take the stove with me, to take the hot water heater with me, not the furnace. The furnace is a fixture. Although in some places you could argue that the furnace is not a fixture. The way it's put in, if I can get it out of there without substantially altering the piping, I can probably take it. So if someone's then coming in and claiming, oh, they should have left the stove behind, I can write in and say, no, there's no reason for that. Let me explain this similar to statutes inclusio unius, exclusio alterius. It's important in a number of places, but if we are regulating horses, and we don't talk at all about dogs and cats, we have, by the absence of that, excluded alternatives, and that's what alterius means. The inclusion of one, the inclusion of a kind, excludes all the other kinds. So if we've got a railroad statute, it doesn't cover trucks. Okay, so we can come in and go, hey, wait a minute, they're trying to use a railroad statute to govern our behavior. That's not appropriate. A general workplace safety law that isn't, so something about ladders in a workplace might apply on a locomotive because there are ladders on a locomotive, but it may not. Anyway, that's kind of going out of the way. All right, so the big deal is, periodically, however, contracts don't really, when we get down to it, completely express the will of the parties. All right, so when might we permit parole or verbal evidence? When obviously the parties are confused about it, or when any plain reading of the language leads us to an ambiguous conclusion. And I'm sorry, I'm kind of drawing a blank on it. I should have one, I guess, written out. If I were a really good instructor, I'd have one written out. What's ambiguous? For instance, occupying a motor vehicle in an insurance policy. What happens if you are getting in or out of the motor vehicle and you get hurt? Let's say that you're getting out to let your kids off at school and somebody drives too close by, takes the door off, and knocks you to the ground. If it turns out they're uninsured, you may want to make a claim under your own uninsured motorist policy, and then they may walk in and go, no, you actually have to be just sitting in the car. Well, it turns out case law makes this pretty plain that we're going to broadly define occupying the vehicle, which is the language in there. And all the languages I've seen in insurance policies now are very plain that it also includes getting into and getting out of your car is part of it. But, places where there may be confusion by the parties, were we to deliver the ship to San Francisco or to your offices in New York Harbor? So if I bring it to San Francisco and you really wanted it at New York, we might go into parole evidence to see hey, should we have figured this out beforehand? I'm sorry, I'm taking way too long again. Um, Here we go to promissory estoppel, or what we sometimes call quasi contract. What we'll find here is that people will periodically sort of enter into a contract and get you to begin to work, and then decide they're going to change their mind. Maybe they found somebody better. Classic example is that the professor gets a student to mow the lawn, and says, I'm going to be out of town in July. Uh, we come back in August. Kid says, hey, I mowed the lawn. And the professor goes, oh, I was just kidding. Thanks. Well, the professor is stopped to deny this under the ordinary set of facts, because we knew that a college student being offered a reasonably certain sum of money, and also having taken contracts law and knowing that there is no need for this to be in writing, would maybe go out and actually mow the lawn. Well, that leads to an unjust enrichment. When I came home from my vacation, hey, my lawn still looked pretty good. I didn't have to weed whack it. I didn't have to do anything else. So even though it may be that I don't have to pay you the agreed price, although ordinarily the courts are going to go, what was the agreed price? Yeah, that sounds reasonable. You pay it. I would have to pay the market price, because in many ways I've been enriched by potentially misleading you. So this comes into play when one party made a promise and knew the other would rely on, and the other party did so act. For instance, in a construction contract, maybe I've got to go rent certain equipment in order to do the contract.